We have been following the Nnamdi Kanu trial for years. We have seen the drama, the adjournments, the DSS raids, and the secret police games. But what we are looking at today, Monday, February 9th, 2026, is a legal blunder so massive, so embarrassing, that it could be the single key that finally unlocks the prison doors for the IPOB leader. The headline is, "The court document the prosecution should never have submitted." And trust me, when you hear the details of this document, you will wonder if the federal government's lawyers were sleeping on duty or if this is divine intervention. We are breaking down the explosive details contained in the fresh notice of appeal filed just days ago by Kanu's legal team. You know that back in November 2025, the Federal High Court, led by Justice James Omotosho, shocked the world by sentencing Nnamdi Kanu to life imprisonment. It was a dark day for his supporters. He was moved from the DSS facility to a correctional center in Sokoto State. Yes, Sokoto, far away from his home base. Everyone thought it was over. Everyone thought the government had won. But here's the twist. In their rush to secure a conviction, the prosecution made a fatal mistake. They submitted a charge sheet, the very document that outlines the crimes, based on a law that no longer exists. According to the new court filings, which dropped on February 4th, 2026, Nnamdi Kanu was tried and convicted under the Terrorism Prevention Amendment Act of 2013. Now, you might say, so what? It's still a Terrorism Act. No. It is not just semantics. That 2013 Act was repealed, abolished, and replaced by the Terrorism Prevention and Prohibition Act of 2022. This is the document they should never have submitted. By submitting charges under a dead law, the prosecution has essentially built a castle on quicksand. In law, you cannot try a man for a crime using a law that has been thrown into the dustbin of history. Kanu's lead counsel, Aloy Ejimakor, has latched onto this error like a pit bull. In the appeal, they are arguing that the entire trial, the conviction, and the life sentence are null and void because the jurisdiction of the court was triggered by a non-existent statute. I have to pause here and ask you, the viewer, because this level of incompetence is hard to believe. Do you think this was an honest mistake by the Attorney General's office? Or is there sabotage from within the government to ensure Kanu eventually gets released on a technicality? I really want to read your theories in the comment section below. And please, if you want to follow this appeal step by step and see if Kanu walks free, do me a massive favor and click that like button right now. It helps us defeat the censorship and spread this news. And if you haven't subscribed yet, hit the subscribe button and turn on the notification bell so you don't miss the judgment day. Welcome back. Let's look at the second bomb in this appeal document. The lawyers are also arguing that the trial court committed a grave error by denying Kanu his right to Allocutus. For those who are not lawyers, Allocutus is a sacred tradition in law. Before a judge sentences you, he must ask, "Do you have anything to say?" It is your final chance to speak to the court, to show remorse, or to explain yourself. The appeal states that Justice Omotosho skipped this step. He handed down a life sentence without letting Kanu say a word. In the eyes of the Court of Appeal, this is a violation of fair hearing. If the appellate court agrees, they could throw out the sentence purely on this procedural failure. This legal breakthrough explains the sudden change in atmosphere we are seeing in the Southeast. Just yesterday, Sunday, February 8, 2026, IPOB officially announced the total cancellation of the sit-at-home order. This directive came directly from Nnamdi Kanu himself from his cell in Sokoto. Why? Because he knows he has a winning hand in court. He needs the region to be peaceful. He needs to show the world that he is a leader who respects the rule of law, unlike, as his lawyers would argue, the government that tries citizens with dead laws. The timeline is moving fast. The notice of appeal has been served. The government lawyers are reportedly scrambling to find a defense for using the 2013 Act. But the damage is done. The document is in the file, and once it is in the file, it cannot be taken back. We are watching the Court of Appeal in Abuja. No date has been fixed for the hearing yet, but with the pressure mounting and the peace returning to the Southeast, the judges will be under the spotlight of the entire world. Will they uphold a life sentence based on a repealed law, or will they do the courageous thing and quash the conviction? One thing is certain, the prosecution wishes they could go back in time and shred that charge sheet, but it is too late.